Hi everyone, my name is Juan Sebastián Sandoval, and today I want to explain to you a WTO law case that concerns about the nation of Australia and how the measures about play packaging are affecting or are supposed to affect the trademarks. So, first of all, we have to review the facts that are next to the case, and when we review that, we need to search the background that happened some years before. So first of all, what we need to know about this case is that the measures that concerns to the WTO law are measures that the products that are affecting are tobacco products, which or what it was the main objective to protect was the public health of the people of that nation. So for reaching that objective, they establish some key areas where they have to work, and one of them was the advertising of the tobacco products. So years after they announced that they will apply, in that moment, what is the object of the dispute here, and is known as the Tobacco Plain Packaging Act. The Tobacco Plain Packaging Act, what mainly affect to the tobacco companies is that they have to use the same matte finish color, also they have to use the same type of font, also the same size for the words, and also they can put any design of the trademark that can distinguish them from the one undertaking from the other undertakings, or that makes reference to the origin of the trademark, the quality of the product. The only exception that they have is the brand name that can appear in the box of the cigars, in the package, and that was what was alleged to the panel, and what also made that in that moment the tobacco companies that work in Australia moved to other parts, other nations. So these measures were analyzed by the panel in with different agreements, with different articles of these agreements, and in their view, as I'm going to explain you, they demonstrate that the Article 20 of the TRIPS were also not violated. The problem that the appellate body is taking into account is that Honduras. Main claim or main issue is if has the panel erred in the interpretation of the term justifiable under the Article 20 of the TRIPS agreement. But subsequently, they also affirm that if the appellate body found that the interpretation of this term by the panel was correct, there are also other issues that have to be solved by them, that are like if the panel erred focus on the economic value of the trademarks and its assessment on the allegedly mitigating factors, but focusing more like in the legitimate interest that the owner of the trademarks has. Also, if they erred finding that the TPP measures are contributing to the reduction in the use of tobacco, if they have erred rejecting other alternative measures that in their view are less trademark encumbering or damaging, and that they proposed, and finally if they are attributing and the legal weight to the FCTC guidelines. So now what we have to review is the rule that is applied to these issues by the appellate body and the panel, and that rule is the Article 20 of the TRIPS agreement, which establish other requirements. So what it says is that the use of a trademark in the course of trade shall not be unjustifiable encumbered by special requirements, such as use with another trademark, use in a special form, or use in a manner detrimental to its capability to distinguish the goods or services of one undertaking from those of other undertakings. This will not preclude a requirement prescribing the use of the trademark identifying the undertaking producing the goods or services along with, but without linking it to, the trademark distinguishing the specific goods or services in question of that undertaking. So in the panel's finding, we are in a case that is applied by the first sentence of the Article 20 of the TRIPS agreement, and the test that is applied in that first sentence is divided in three stages. The first of them were established is if we are under a special requirement, and the second of them is that if this special requirement is encumbering or is affecting properly the use of a trademark. After knowing that these two stages were passed and they were not claimed and they were not appealed, the discussion centers in the third aspect, that is, if these special requirements that are encumbering the use of trademarks are justifiable or not. After the panel review a large number of definitions, they concluded that when we are talking about the unjustifiable term, what is relevant is that this special requirement that is encumbering the use of a trademark is or has a lack of justification or reason that support this encumbrance result, or taking into account if we are under good reasons that justify these encumbrances, we or they also have to review that in the Article 8 of the TRIPS agreement, there are established that the WTO members can pursue some social legitimate interests as for they is clear the public health. So finally, they define that there are three aspects that has to be also checked when we are talking about unjustifiable special requirements. The first of them is how is the nature of the measure, which is the nature of the measure, and the extent of it and the extent of the encumbrance. Also, the second part of the test is if the reasons that support the encumbrance are reasons that really support social interests that are protected under the agreement. And finally, if that the reasons that are taken into account provide a sufficient support for the resulting encumbrance, but this is more like reflected if they are really effective in the practice and in the results. So what the panel said about the first aspect of the test of the nature of the requirement is that if the requirement prevent any non-word component of the trademark, as I told you, it also has been demonstrated, and the complainants hasn't demonstrate that in the practice, the users of the tobacco products hasn't been allowed to distinguish the trademarks. This fact for the panel makes that the nature of the measure is not an ultimatum and is more a far-reaching measure. About the second part of the test, what the panel found is that Australia has a legitimate interest, and what the reasons that they applied for this special requirement is that they are pursuing a better public health and better health care of their society. So finally, in the last part of the test about if the reasons are sufficient to support the resulting encumbrance, what the panel found is that these measures are capable, and in fact they are doing what is the objective of Australia, and that is reduce the consumption of tobacco and the exposure of these products to their society. So after these conclusions of the panel, what the appellate body enters to review is this summary. And what they define is that when we are talking about the Article 20 of the TRIPS agreement, we have to first know that this is not an exception of the rule. Instead of that, this is an obligation that is referred to the members to retain them from any unjustifiable encumbrance resulting from these special requirements. So now in resume define is that the term justifiable is in a situation, or what it is referring in this case is a situation when there is no fair reason or there is no a reasonable way to explain this to support. They also add in their view that it is like a source, a degree of rationalization that needs to be provided for support this special requirement, but that it is very relevant to know that when we're talking about this term justifiable under this article, this is very different from the term necessary and the exam, as the panel before also said, from a term like the Article 20 of the GATT or the Article 2.2 of the TBT agreement, that is the term unnecessary. When in this exam, for example, of the test of a term necessary, is necessary to review also different possible solutions or measures that are less damaging. And when we are talking about this Article 20, that is not necessary. It could be reviewed for seeing if we are really under a justifiable special requirement, but that is not mandatory. The appellate body concludes is that it has been proved that the complainants hasn't proved or affirm or demonstrate that the reasons that are supporting the resulting encumbrance of the special requirement are not justifiable. Now about the other issues that Honduras claims, what the appellate body says is that first, about the erroneous economic value that Honduras affirms the panel attributed to the owners of the trademark. They say that the panel take account the interest that the owner of the trademarks have in their design and the economic value that they can give to them, but that in fact the complainants haven't proved how the users of the tobacco products haven't been able to distinguish one product of one undertaking from those of the other undertakings. So this made that we are not talking about an ultimate encumbrance as Honduras affirms, and instead of that we are under a measure that is far-reaching. Another issue that Honduras claims is that if really does these measures contribute to the reducing of the consumption of tobacco products, and if really the panel take into account other measures that could be less encumbering for the trade. In the first of these points, what the appellate body affirms is that it has been proved that with this measure of remove the design features of the tobacco products, these have an effect of reduce the appeal that these products have for the consumers, and that also taking in response to the second point that well, it is not necessary to evaluate other measures under this test. The panel did it, and did it under the Article 2.2 of the TBT agreement, and what they affirm is that the complainants hasn't proved how any of these other possible measures have the same results as the TPP measures has. Finally, the last issue that Honduras is claiming is that the panel give an erroneous legal weight to the FCTC guidelines, but what the appellate body affirms about this topic is that these guidelines were only taken as an additional factual support to the conclusion that already the panel has proved, and that these FCTC guidelines are not a commitment for the members. That is just like a suggestion for the members to adopt measures like this.